It's not unusual for me to talk to older survivors who will recall what they feel with great emotion, having been raised in a family where there's domestic abuse, and it's obviously impacted them their entire life, and they feel so strongly. So this notion that somehow if the physical violence or the kind of absence of someone kind of in your life for a relatively short period of time means that in court it's considered historical, I think that is still a huge problem for children. And that's why, as Jacky said, we must tune in and have the ability to get to know the child, understand the impacts, understand their view, get beyond some of these labels and really understand what any kind of reluctance could be about. Really, we owe it to them because these are life-changing decisions that courts are making.
Thank you. If we can move on to, still on the topic of relationships, really, that you've just moved on to, and talk about alienation of a child, and perhaps we can bring Jacky in as well on this one, please. Where there's allegations that one parent has alienated a child from the other parent, in both of your experiences, is the court able to adequately assess those allegations fully and respond to that behaviour appropriately at the moment? And if not, how would you like things to be improved in that respect?
I feel like you all are so much more expert than me.
Okay, just in terms of alienating behaviours, our policy and our position on alienating behaviours is that when it is alleged in a set of proceedings, that our first question about why a child might be refusing to see another parent is there domestic abuse or another form of harm, sexual abuse or physical abuse? And that's the starting point for us for that child. And if our assessment is that those other forms of harm aren't present, then we do go to why would the child not want to spend time? And there are situations where parents are in conflict and one parent says horrible things about another and influences the child. That happens. There's many, many cases. But what we've done to strengthen the position that it's not used in the proceedings inappropriately is to start with domestic abuse. So family court advisors in the policy are required to say, why doesn't this child want to see this other parent? And we choose to resolve conflicts and arrangements for children in this country with their parents through the family court. Whether that's the right situation or not, other countries do other things, but we do it in the family court. It's an adversarial space. And the court is stuck between having to make a decision to do a fact find in those cases, which will create delay and slow the whole system down, or not. And those are difficult decisions to make. And I think we just have to be thoughtful about what we're doing to help social workers recommend fact finds or not. When should you, when shouldn't you? And also for the court then to make its decision about whether that's a reasonable piece of advice or not. But in the cases that require that allegation to be investigated, then there should be a fact find. And where there is alienation and domestic abuse in the same conversation in those proceedings, that the only way to investigate that is for the social worker to put their advice to court and the court to have a fact find.